Yes, I'm Miller.
Yes.
I beg to mention adjournment 12 Miller.
Oh, supplementary hearing.
Miller. I am not ready with a brief, Miller. May I pray that this will state up.
Huh? Yeah, he doesn't have a case, so that's why. Anyways, you are for the
Respondent,
for-
Miller. Respondent.
respondent. Oh, okay. On the submissions made by the learned counsels for both the parties, list after 1 week. Yes,
Let it be 2 weeks, Your Lordship.
pardon?
Let it be 2 weeks, Your Lordship.
Okay, after 2 weeks.
Okay.
For other job, there's nothing.
Yeah, of course, that is true, Miller. He is working, works as employee.
We'll keep
Okay.
adjourning then. Yes.
Yeah, Lordship, ma'am mentioned item number 3. In fact, in this matter, the criminal appeal paper book is ready. So matter may be fixed for hearing next week, and date may be fixed.
2 and 3 is the same.
Uh,
Paper book ready in both of them.
3. Mine is 3.
Ah. So what about 2? 2 also same? Paper book
Yeah,
is
2 also
ready?
same, yes, but then 2 is
It becomes like this out of
different
turn.
matter.
Anyway, Mr. So-and-so, learned counsel for the applicant, submits that paper book is ready and duly furnished to both the parties. In view of the above, list the matter for hearing in due course. In due course. What? Oh, list on 8, 20.
Your Lordship, let it be on 13th, Your Lordship. The other
Okay.
side, respondent, here the victim is also there, Your Lordship, in this case.
Okay,
So let it be a fixed matter on 13th, Your Lordship, for final
Okay.
disposal.
yes, list on 13th, 13/8.
Yes.
Yes, paper books are received by the council for respondent number 2 also, yes.
Oblige. Deeply obliged, Your Lordship.
Lordship, this is a public interest litigation. So. Not late, Lordship. This petition is more particularly with regard to Lordship. Number 1 is deprivation of private land during the course of land without any land acquisition. While executing this Pradhan Mantri Gram Saurya PMGSY scheme. This PIL has been filed on the basis of this information received under RTI. As per the RTI, since 2005 to 2024, as on that, it is in Arunachal Pradesh, 1053. PMGY road has been executed by the state department, state government. But in none of the case, no land compensation was given.
Must have been voluntary given
no,
by the
that is-
villagers because it's for their benefit also.
Yes, that is the
PMGSY, if there's going to be a road through
Lordship.
your village, you're all going to benefit.
Lordship.
So I must have been voluntary given to, isn't it? Because,
If it is,
because the provision says if it's
Yes.
voluntary,
if it is a case of volunteering, there is no case. Lordship.
so is there any protest made by the
Lordship-
landowners?
Lordship, generally it is said, as per the narrative received from this department saying that there is no compensation provision under the PMJ.
Obviously,
This
it's
is the
not
point.
there. Huh.
This is the point. But
That's everywhere.
what has been given in the PMCSI guidelines?
Huh.
PMCSI guidelines, initially it was money was to be this 16 to 40 ratio. This was money was to be this for
Huh.
allocation, fund allocation was like that. Now it is at present, it is 100%, it is the responsibility of the state to acquire land At the time of this pushing of this scheme itself by the user department, user agency, the land availability certificate has to be enclosed. That is to be as per record.
Hmm.
But generally, it is said to the villagers that there cannot be any land compensation. But never
Yes, why does
that
not have
the
that
party has
provision?
to, the authority has to negotiate it with the department. What I am quoting this page number 12 of my PIL. What PMGSA guidelines say.
Oh,
This is the guidelines.
you see, having good roads is for the upliftment and
Absolutely.
benefit of the villagers.
Yes, as
So they
per the
welcome
guidelines,
and donate their lands in other
As per-
states. So I don't know here, what is the problem?
as per the
Huh.
guidelines, what is say?
Uh.
It has been stated. May I read the
Yes.
para 6.2 of the PMJSY guidelines?
Hmm.
It says, as in terms of the guidelines, there is no provision or fund provision for the land acquisition. However, the obligation has been casted upon the state respondent or state government or user agency for management of the land at own cost. That may be in the form of land acquisition.
Hmm.
Another is voluntary land donation. It may be exchange or any other mechanism to ensure land availability at the time of placing scheme for the PMGSY project. Further, it has been provided that the process of making land availability certificate for the road work should subserve the common interest and common good and shall also be just and reasonable. The details of land availability certificate should be reflected in the local land records. It should be reflected in the local land records of the department to avoid any kind of disputes.
So are there any disputes right now?
No,
You're inviting
lordship,
disputes.
my point is,
Isn't it? There are
my-
no disputes. Are there any-
my point is generally due to ignorance as per the narration of this department user agency, there is no provision for land this land compensation provision. That is why there cannot be any land. There cannot be any compensation. That is the narrative.
Mhm.
That is why
PMGSY, that's what it is. That's
That
what
is
the
why
dictum is there.
the department has to show how this land has been obtained. That has to be seen. How this all those schemes, how the government department is availing this obtaining the land availability certificate at the time of this pushing these schemes. Because
So the
without any
roads are
consent,
constructed, the roads are constructed?
because without any consent of the landowners, that is, may it be a private land, may it be a community land, generally, yeah, PMGSY schemes are executed in the rural area,
Oh.
in the
For the
village
development of the
village
rural
connecting road.
Yes.
That is a generally forest land.
Common good.
In the forest land for the common good, even then, the community has right to, they may,
So have they protested the community anywhere showing that they're demanding compensation?
lordship, that is the ignorance, lordship. That is the ignorance. Just they have been pleased. The village people have been pleased, saying that we
They're
are
having
bring,
a road
we
in the
are
village.
going to bring road to your
Yes,
village.
yes.
That is why land availability, without following the due process of law, land availability certificate has been
Where is it shown that?
enclosed in the scheme in advance without taking any consent from the department in all of the cases. That is the one of the main contention. That is that when the consent of the landowner is not taken, that is a violation of the Article 300A of the Constitution of India.
Who are the landowners
the
whose consent
property
had to
owner,
be taken?
the property that
Yes.
there is a mass deprivation of the landowner by the user agency.
Who are the landowners? Have you listed their names?
Landowner is
Is there in the RTI this thing application, private landowners?
This is
Or is it community land? Have you found out?
This is a lordship 1053 roads as per the revelation RTI.
Huh.
This case has been filed on public interest, saying that in none of the case why there should not be a land compensation. Why there should not be a negotiation with the department? That
But-
may be in the form of exchange.
I don't know if.
Why
that's-
there should be, why there should be a cheating with the community by enclosing advanced land certificate, land availability
don't know.
certificate in the documents in the scheme without obtaining any consent from the community landowner. This is one of the issue here. And another aspect of the case is there is a whenever
Consent is required because PMGSY road in, okay, like in the state of Mizoram, it's welcome and the village councils, they donate their lands because it's for the development of the whole village if they have a road. So they're welcome. So here, when there is there, if there's any complaint by the landowners demanding compensation, it's a different matter, then they can. Otherwise, saying that they should be compensated when they are not in grievance. I don't know whether that will become a public interest
lordship,
litigation.
lordship, if the
Because
owner
it's
of the
for
land,
the public.
yes, if the
at
owner
large.
of the land raise this issue, that will be a writ petition lordship. If the community is agree, if that particular person is agree.
It's for the public interest.
This is for public interest, saying that this enclosure of land availability certificate without obtaining the consent of the community landowner, that is
But
cheating.
supposing land
As-
was not available, how can they
Yeah.
construct the road?
Because,
They've constructed.
because,
Any protest? Why
because,
not?
because generally public are, they are ignorant, public are generally convinced. That cannot be the rule.
But
Rule is otherwise, lordship.
isn't construction
The
of
PMJ
the
is
road in the
PMJ
interest of the public? That's what
Yes.
I'm trying to understand. Public interest litigation,
Generally,
construction of road, they should be demanding that road be constructed within their village. That's the public interest.
that is not the, that is a, there are generally, generally how PMJ scheme, there is a department in the,
Bad
rural-
roads,
rural
no roads
depart-
in the villages, we want a road, that should be the public interest litigation.
that is one of the aspect, that I. have said.
Anyways,
That is,
huh. What is the
my,
second?
my point is
Okay, the second
deprivation,
point.
deprivation of, this, land right.
Invitation litigation. Oh, that's very nice. Because they invite in litigations. I haven't seen it. Okay, what is your second aspect? Second point? There were two points.
Ah.
The second one.
that's
The second one has.
Yeah.
Second one?
Yes, I'm just completing this,
Hmm.
this part. Apart from this, as per the section 2 of this land settlement, Arunachal Pradesh land settlement and record act 2002, this community land right has been defined. The land which is not defined as per the land record, which is a lush green forest, this occupied by community, that is the community land. Most of this land which over which this PMJ SY scheme has been executed is a community land.
Hmm.
That is one of the points. That is why land
But the
right, number of
upliftment
this
of the
land right, have been-
community.
community land right has been
So
deprived.
should we stop the PMGSY roads being constructed? Then
Yes.
the villagers will suffer. They will have no road.
No, we are not on that lordship. We are on
Public
that,
interest.
we are on that, there should be a consent of the department. There should be a consent of the department. The procedure has to be followed as per the PMJ
Okay,
guidelines.
show where the
Why-
procedure has not been followed.
Why the user agency should not this comply the PMJ guidelines, which the strict adherence is required. That cannot be the procedure. One of the aspects.
Okay,
And
huh.
another aspect is the Forest Conservation Act.
Oh,
As per the section 2 of the Forest Conservation Act, says when the forest land is converted to non-forest purpose, there should be a regulatory body for control and management of the forest. That is a part of the environmental justice. This honorable court has right to
Hmm.
give direction over this. Issue, there is a landmark judgment of this honorable Supreme Court. T and Godavardan case is there. in over which already direction has been issued for framing this guidelines for regulatory body for execution of environmental clearance. One is forest clearance, another is compensatory afforestation. When there is a conversion of forest land into non-forest purpose. That is one of the points. In this case, in this PMCSY guidelines, it has been clearly mentioned that whenever scheme is executed, the forest department should be involved. But in none of the case, the user agency involved the forest department, which is in contravention of this procedure laid down by law. That cannot be. That is why in this connection, may I, Lordship, take your Lordship to page number 219. 219 of PIM. I'm precising that this reading. Out of these various representations submitted by the petitioners, being a social activist, this application has been written by this letter has been written by the Ministry of Environment, Forest and Climate Change, Integrated Regional Office, Guwahati, written to the Principal Chief Conservator of Forest, Department of Environment, Forest, Government of Arunachal Pradesh, saying that filing of FIR against illegal unauthorized diversion of forest land and construction of 1053 PMJ road in Arunachal Pradesh. But no action has been taken as agenda in this connection for in the part of this environmental justice. Forest laws, regulatory body has been completely skipped off. Nothing as such. And again, I'm coming to page number 221. This is the application letter written by the one KV Singh of additional PCCF, Government of Arunachal Pradesh, has written in compliance of in pursuant to that letter to all chief conservator of forest, saying that in the operative portion, therefore, in the last paragraph I'm reading, therefore, it is requested once again to direct the concerned DFO for early submission of the details along with the status of the land on which it has been constructed. In case of any violation of FC Act 1980, the action against the offender for violation may be initiated immediately. But no action as such till then. Whereas as per the PMCSY guidelines, forest department should be involved whenever the scheme is, the project is carried out. In this connection, Lordship, the petitioner has even submitted in the page number 233. I'm coming back to the point for land compensation. One is one of the issues land compensation to this community landholder, and another is this violation of environmental laws without any regulatory body, control of the regulatory body. Forest land are diverted into non-forest purpose. Again, I come to page number 233. This is the letter written by this the Forest Department, Deputy Inspector General of Forest, to the Principal Secretary, Government of Arunachal Pradesh, in which direction has been issued.
Okay,
May I read the contents again?
yes, conservation of forest,
Yes.
there you may have a point.
Yes.
Because conservation of forest is something which is very important.
Yes.
It's in fact, an issue that it's for in the interest of public and in the interest of the global environment as it is. Yes, it's getting hotter and hotter, isn't it? So the second point, you could have you could have a case.
Yes.
So
Yes.
would it be in the
Yes.
interest of the public regarding the afforestation without following the proper procedure? But your first point, whether the landowners should be paid
This-
compensation or not has to be looked
this-
into.
This
Because to
honorable,
see if there's any grievance or not.
yes, this
But I
honorable,
think at this
this
point,
honorable,
we should notice- oh, what?
yes.
Yes. Not, yes, not the compensation, you can't demand.
This
compensation.
honorable court may, on public interest, since this application is for public
we-
interest, any of the point,
Yes,
any of the,
record our
prayer-
observations. Okay, and we'll issue notice.
yes, any of the point, this
Hmm.
honorable court may issue notice.
Yes. Heard Mr.
Titapak.
Titapak. Learned counsel for.
Before your lordship
Petitioner,
passes
yes.
any other matter,
Yes.
my lord, as your lordship ever, my lord, this PMG's why it was launched by the Prime Minister 2000, my lord,
Hmm,
for those rural areas which are
Hmm.
not connected, my lord.
yes.
Now, as per the central scheme, my lord, there is no concept of land compensation. The state authority, they have to give pre-incumbency all the land and deeper has to be given to them, my lord.
No, we're
The
we're
land that
not
was-
convinced.
Yes.
We're not convinced
Huh.
so far as the
Compensation.
compensation is concerned. We're issue notice on the issue of violation of environment.
Environmental, my
Environment
lord.
laws.
That we have to
Because
see.
they have filed a petition and it is forwarded to you and you have not taken any action. On that issue, we can.
Obviously, my lord, if somebody lodge a complaint, they will be redirected to the
Sustainable-
concerned authority, my lord.
Sustainable development.
My lord.
Environment has to also be protected.
Now, beside that, my lord, now it's again come the technical issues, my lord. As your lordship knows, my lord, we have a Guwahati High Court rules on PL 2000, my lord. Now, as per rules 10, my lord, D.
Okay, we'll keep it open.
So,
Maintainability.
maintainability,
Maintainability
your lordship may keep it
will
open, my
be
lord.
open with the rules that
Yes.
will be there. Okay.
So, what I want, my lord, if there is any rules, my lord, it must be followed letter in the spirit, my
Yes,
lord.
yes.
So,
So
that
whether it's
maintainability,
actually
maybe
the
lordship may
public
keep it open,
interest.
my lord.
That is equally he's saying. There is a laws regulating the environment. You have not followed.
My lord, those, my lord, areas, definitely wherever the NOC from the forest is record or from green tribunal. Obviously, my lord, they must have acquired it. Without, my
have.
lord,
So you
yes,
check
there
whether-
cannot be any sanction from the central government, my lord. That is his person, my lord, yes.
That's
No, he has
his
filed an
allegation. huh.
application and then it has been forwarded to.
Yes, provided to PCCF.
You might have acted on it.
One is his allegation, which you have to see. And construction of roads. I think that's in the public interest.
Obviously, Malaysia rural connectivity, Malaysia
Yes.
public interest.
Heard Mr. Learned counsel for the petition, who has filed the instant public interest litigation. On the grounds that the Pradhan Mantri Gram Sadak Yojana, within brackets, PMGSY projects in the state of Andhra Pradesh, Arunachal Pradesh, I'm sorry, I'm thinking of something else. Arunachal Pradesh has not been implemented properly. Full stop. He submits that as per the information obtained by the petitioner, it is seen that the respondent departments have constructed 1,053 PMGSY project roads in the state of Arunachal Pradesh since 2005 till date. Full stop. In none of the cases, the user agency has paid any land compensation to the landowners, stating that there is no provision under the PMGSY projects for land compensation. He further submits that the user agency has also not obtained environmental clearance within brackets EC certificate or forest clearance within brackets FC from the competent authority, so that compensatory afforestation are implemented under Kampa scheme so as to recover the forest area lost. The Learned Council submits that with regards to the afforestation and non-obtaining forest clearance, he had also written to the Principal Chief Conservator of Forest and HOFF in a letter dated 05/12/2022. And yes, which is the other letter? And to the Principal Secretary, Government of Arunachal Pradesh, Department of Environment and Forests, in a letter dated 24/01/2024. To give information. No, and the, cancel that last paragraph. And the Deputy Inspector General of Forest had written to the Principal Secretary, Government of Arunachal Pradesh, Department of Environment and Forest, in a letter dated 24/01/24, to give information regarding the complaints whether forest clearance was obtained before the construction of roads under the PMGSY road, PMGSY scheme. The Learned Counsel submits that these two aspects are in the interest of the public and for issuance of necessary orders against the respondents as prayed for. Having considered the nature of the submissions made by the Learned Counsel for the petitioner, we find that the construction of PMGSY road, the construction of roads in rural areas under the PMGSY projects / schemes is in fact in the interest of the public. And as per the scheme, it is seen that the land is to be provided by the state government, either as, where's that part that you had read? 6 of the PMGSY, yes. There was one para you had read concerning para page 12. Yes,
That's correct.
so we will type out the scheme, which is in page 12
Yes.
and within inverted this thing. Okay. A perusal of para 6.12 of the PMGSY scheme guidelines shows that it is cast upon the state government user agency for management of land in the form of land acquisition / voluntary donation / exchange or other mechanisms to ensure land availability. Full stop. The Learned Counsel for the Learned Counsel has not been able to show any objection that is raised by the land owners or the community land belonging to the community, whether the community has objected to the acquisition of the land for implementation of the scheme. In view of the above, considering the fact that the construction of the roads itself is in the interest of the public, we do not find that the elements of uh, a public interest litigation lies in the first point. However, we find that it would be appropriate to issue notice to the respondents with regards to the second point, that is whether forest clearance has been acquired at the time when the PMGS scheme was implemented and roads of so-and-so kilometers were constructed within the year 2005 date. Notice be issued to the is it okay? Anything on the letter? Notice is to be issued to the respondents, Mr. So-and-so. Okay. Accepts notice on behalf of respondent number 1. Yes. Anyone else? Notice be issued to the other respondent.
LM is here. And
Okay.
Forest
So
Department
while
is.
we come to
Yes, madam.
learned standing counsel for respondent number 2.
Yes.
Accepts notice. Anyone else? Notice be issued.
So far, my lord, respond with 3, 4, 3 and 4, my lord, they have the standing counsel, my lord, RWD department.
Okay. So we
Mr.
issue notice to this thing, okay, to registered post
Yes,
with AD within 3 days, returnable by 3 weeks.
yes.
List after 3 weeks.
I'm sorry, ma'am, I'm representing respond number 6 also, my
Six,
lord. 6
Okay.
also.
1 and 6. Yes, requisite extra copies of the said public interest litigation to be duly issued to the learned counsels for the respondents present today. Yes.
Your lordship may kindly add one more line, my lord. The
Yes.
mental leave to PL may be
Yes,
kept open, my lord.
The maintainability of the instant PIL is left open to be considered in the next
Next
date. Yes.
Lordship,
Huh.
the service upon the victim is still awaited, Your Lordship. Though we have sent it to the officer in charge, we have not received the receipt of the service, Your Lordship.
Heard Miss Ginny, learned additional duty. He submits that. Return of service report upon respondent number 2 is still awaited. In view of the above, list after
2 weeks, Your
2
Lordship.
weeks.
Your Lordship, we have also received we have not received the paper book, though it's in the court's record, Your Lordship. That may also be issued.
Who was the appellant? Anyone?
It's a
appearing
jail
for-
appeal, Your
Okay,
Lordship.
jail appeal.
Meanwhile,
It is seen that paper books are prepared and ready. Copy is to be duly furnished to the learned additional PP. Now for the appellant, amicus curiae has to be appointed.
appointed, Your Lordship.
We also find it appropriate to appoint who? An amicus curiae for the appellant, since the matter is a jail appeal. Registry. Do we leave it in the registry or appoint from here?
Your Lordship can also appoint, however, there is a list of amicus curiae with the registry, Your Lordship.
Okay,
can also
okay,
direct.
registry to appoint an amicus curiae as per the existing list.
Well, at number 4, 5, and 6, it is connected, my lord. My lord, the earlier round of litigation, my lord, attestor has appeared as a counsel, my lord. In this.
Yes, okay. Then let's this matter before any other bench except this bench. Before any other bench without one of us, okay? And then within brackets, the name of.
Declare, my lord.
Item number 7.
This also.
May I plead your lordship, this matter related to
Yes.
Okay,
Cons-
here also, I think his lordship was there. It appears.
yes.
In the earlier,
Yeah.
earlier, same issue.
Okay, then
yes.
same order, is it? Except, without one of us, then before any other bench.
Right.
one. Yes. Lordship, I have already complied.
Paid.
Yes, I have paid to the deputy commissioner's account. The whole amount. Okay, who's for the, you received?
Not yet. I've not received yet.
I have deposited at deputy commissioner's account. Okay. Yeah, then we'll fix another date wherein it should be paid positively to the petitioner. Isn't it?
Why you are holding?
He's the deputy commissioner. You're waiting?
You disperse.
This can be closed, the contempt petition can be closed since money has been
Yes,
deposited.
petitioner, can we close?
Yes, if money is being deposited, then it can be closed.
Okay, it's deposited with, so you're satisfied with that?
Yes, yes.
Okay, Mr.
Six,
So
yeah.
and so,
Deposit ho gaya na.
learned counsel appears on behalf of the petitioner.
Lordship,
What?
my humble request, connect the council, he is not available today. So kindly, for closing,
Yes.
kindly let him
mention
appear by
is
himself.
made
Yes,
on
yes.
behalf of Mr.
M. Kambo,
M.
on behalf of
Kambo.
Mr. Arsonar,
Okay, Mr. So and so makes mention on behalf of Mr.
Arsonar.
Suran, learned counsel for the petitioner for adjournment of the matter since the learned counsel is not able to appear today due to some personal difficulties. Mr. So and so, learned counsel for respondent number six
Deputy Commissioner.
submits that, and Miss so and so, learned counsel for respondent number.
There is your petition.
You are
I
for
think
which
one, two,
respondent?
1, 2, and 7.
1, 2, and 7.
1, 2, and 7
1, 2, and 7.
submits that this matter can be closed since the compensation amount has been deposited and is lying in the account of the deputy commissioner. Yes, okay, full stop. However, since the learned counsel for the petitioner is absent, does this matter? When? In the next week?
Instead of keeping this pending, may I kindly close this case with a direction to the Deputy Commissioner to disburse the compensation amount in view of the compliance made by, then it serves the purpose. Why to keep this matter pending?
In the next week, let him be this thing, okay? Because
They were
he's
in-
just sent his,
No, they were,
he's
they,
just sent his junior and the junior will scold him.
No,
Why did you have it this, okay? What were the
Lordship,
instructions?
leading council, he will be present on 5th of August.
Okay, on Monday.
Yes, yes.
This
Monday.
is matter on,
it's fine. We wanted them to
Okay.
get the money as early as
Yes,
possible.
my lord, even the award has been already met, my lord.
made, it's,
You-
but it's not in
Very
the
sure,
pocket
sir.
of the, but
No.
it's not, still not in the hands of the petitioners, isn't it? So maybe they have some apprehension.
Do you disperse before Monday? There has already been deposited. So that
Why
you
you
can,
keep-
My lord will make observation, one line.
no, it's a,
No, list, this thing, in the meantime, the council for respondents number, deputy commissioner, is
Six.
respondent number, 6 will take steps to disperse the deposited money to the petitioners.
But in accordance with rules. In accordance with rules.
Okay, in accordance
accordance
with
with
existing rules. yes.
Whether there's so many flows will come up in between.
In accordance with the existing rules, yes.
Grateful.
Obliged.
Please.
Lordship, item
Okay. Yes.
Lordship,
The previous one, we will just say to make the payment, an attempt to make the payment within the next date, okay? The rules will be deleted. Okay. Yes.
Your Lordship, item 9, Your Lordship, on the last occasion, Learned Counsel H. Lamp, whom was appointed as an amicus, Your Lordship. His name has not been reflected in the cause list, however, Your Lordship.
Has he been informed that he's an amicus in this matter?
His name has not been shown in the cause
Not in
list.
the
Your Lordship.
registry, so the registry should also inform. Ms. T. Ginny, learned additional PP for the state respondents is present. It is mentioned that the name of the amicus curate appointed to represent the appellant has not been reflected in the cause list. In view of the above, the registry to do the needful and the appointed amicus curiae, Mr. H. Lampu, is also to be informed of his appointment by the registry.
Your Lordship can fix this matter for hearing otherwise, Your Lordship.
But paper book, everything,
We have received the paper book.
you
The
have, but
paper
what about
book,
the others?
yes,
Okay, we'll listen shortly, list in the next week.
Lordship, item number 10 is also arising from the same judgment and order in item number 9, Your Lordship. In item number 10, it's filed by
But
the,
here they have a counsel.
yes, private.
Okay,
Your Worship, I'm appearing on behalf of J. N. Das, conducting counsel. Your
paper book is ready.
Yes, Your
Worship. I've
Lordship.
not received the paper book.
A paper book is ready, Your Lordship.
It was prepared on the expense, at the expense of the appellants, isn't it? Since,
I'm not sure.
No, Your Lordship, since item number 9 and 10 arises out of same judgment and
So
order,
they are
same
lucky.
paper book.
they did not pay, isn't it? Because they are the appellants here, it should be made. Anyways, Mr. So-and-so makes mention on behalf of Mr.
N. J. Das, Your Worship.
N.J. Das, learned counsel for the appellant, for adjournment of the matter, since the learned counsel is not able to appear due to some personal problems. Ms. T. Ginny, learned additional PP, submits that paper book is received. In view of the above,
Your Worship may kindly keep fixed there, Your Worship.
steps is to be taken to furnish copies of the paper book to the learned counsels. List. When you want it,
9th of August, Your Worship.
list on 9/8/2024.
I will.
Yes.
Lordship, this is read appeal. This interlocutory application, there is a delay of 32 days in filing this appeal against the single bench order.
Will issue notice first, isn't it?
The ground is Lordship, actually
Will
this,
issue notice,
Yes.
let them, then next short date we'll see whether they want to file any objection, isn't it? Heard Mr. So-and-so, learned counsel for the applicant who has filed the instant application for under section 5 of the Limitation Act, 1963 for condonation of a delay of 33 days in preferring the instant writ appeal against the judgment and order dated 27/05/2024, passed by the learned single judge in WPC number 315 within brackets AP/2028. Issue notice to the respondents, Ms. So-and-so, learned government advocate,
Lordship.
accepts notice on behalf of respondents number,
All the
state
respondents.
respondents, okay,
All the
on behalf of all the state respondents. No need to issue formal notice. Requisite copy of the instant IA to be duly furnished to the learned government advocate. List after 1 week, simple matter, after 1 week.
all right.
Yes.
Lordship, if I may. Lordship, I'd like to mention item number 5, Lordship.
I think it's your practice here to mention, yes. Even
Lordship.
those which are not for supplementary hearings. Anyway, item number 5.
Yes, Lordship,
Yes.
in this case, 2 cases were filed yesterday arising out of the same FIR. However, one case is listed here and one case is listed as item number 2 in code number 2. So it
Okay,
is,
so should be listed in code number 2.
it may be
Certain.
taken up together with item number 5. I'm praying that
Okay.
the item in code number 2 may also be taken up along with.
It'll be, this will be sent to code number 2. Okay.
Yes, my
On the submission made by the learned counsel for the applicant, since on the submission made by this matter is to be listed with AB what?
AB 100,
Item number 2
110,
in code number 2.
code number 2.
Along with AB 110/2024, which has been listed in code number 2. Okay. Accordingly, this matter is to be sent to code number 2.
Much
Yes.
obliged, Lordship.
Lordship. Lordship, I'd like to mention item number 28. Your leading counsel, Mr. K. Tayang, is out of station, Your Lordship. So I pray the matter will be listed after 1 week. I have taken the.
Okay,
consequence.
Mr. So and so learned counsel for the petitioner has prayed for adjournment of the matter with the consent of the respondents. In view of the above, list after 1 week.
Obligation.
Please, Your Lordship. Lordship, I beg to mention item number 12 and 13, Your Lordship.
12 and
13, Your Lordship. The response
21,
12 and 13, Your Lordship. 1,
12
3.
and 13.
Yes, yes.
Yes, yes, they're listed together anyways, huh?
Yes, Your Lordship. Lordship, the respondents have filed an affidavit yesterday in both the matters. We have received the copy. Only yesterday it was filed. So I'm for the
Okay,
petitioner.
Mr. So and so.
Yes.
Is your name here?
Yes, Your Lordship.
Your name?
KJ Saikya, Your Lordship.
PG Saikya.
KJ Saikya, Your Lordship.
Okay,
KJ.
KG Saikya. Learned Counsel,
We need to file reply, Your Lordship, in both the
Learned Counsel for the applicant slash petitioner has prayed for time to file their reply affidavit to the counter affidavits filed by the respondents.
the matters may be
Above.
listed after 3 weeks. Yes.
List after 3 weeks.
Lordship,
Oh,
there's an interim order in 196, Your Lordship, the
In which?
item 12,
okay, in view of the above,
the interim order.
interim order passed earlier shall continue till the next returnable date.
Deeply obliged.
Yes.
May I mention, my lord, one, 2 read petitions for listing tomorrow, my lord. My lord, in fact, I made a mention before the court number 2, my lord.
Oh,
His lordship, my lord, was of the, my lord, to.
what is the urgency?
My lord, this is service matter, my lord.
Pardon?
Service matter, my lord. Transparent posting.
Okay.
My lord, may kindly, my lord, refer the matter to this court number 2, my lord. This is for only.
Okay, yes, can be listed tomorrow before quorum number
Right.
2. Yes.
Your Lordship, I may be allowed to mention item 10.
Yes.
Here I'm for the petitioner.
Oh,
I have taken the consent from the other side also. Kindly, Lordship, a fixed date may be given for August 28th.
mention is made on behalf of Mr.
Arsoner.
R. Sonam, learned counsel for the respondent for adjournment
No,
of the
for
matter.
petitioner, I'm for the petitioner.
Oh, okay. Then, okay, learned counsel
for
for the
respondent number 12.
petitioner for adjournment of the matter with the consent of the respondents.
Kindly fix
We
that for
approve.
August 28th.
List on,
August 28th August.
okay, on 28, 2024.
Okay.
Yes.
Much obliged.
May it please your lordship,
My lord, I beg to mention item number 33. On behalf of K lawyer.
Mention is made on behalf of Mr. K. Lawyer, is it?
yes.
Learned counsel for the petitioner for adjournment of the matter. Consent is taken
Yes.
with the consent of the respondents. Review of the book. List after
3 weeks.
3 weeks.
And my lord, there is an interim order.
Meanwhile, interim order passed earlier shall continue till the next returnable date.
Much obliged.
Please, Lordship. Lordship, I beg to mention item number 19.
19.
Yes,
Yes.
Lordship. I have already taken consent from the petitioner and the state respondent. So I have to file my affidavit in opposition on behalf of private respondent,
Okay, Mr.
Titaba.
Stowens, T. Tapa, learned counsel for the private respondent has prayed for further time to file his counter affidavit in view of the above. List after 3 weeks. Yes,
Item number 19.
19, huh?
Yes. WPC 294. Deeply obliged.
Yes, first order.
My lordship. Lordship, I beg to mention item number 31 and 32, lordship. I take consent from the other side, lordship. A matter may be listed after 4 weeks, lordship.
With the consent of the respondents, Mr.
K. Lauren, lordship.
K. Loy, learned counsel for the petitioner. In item number 31, it will be petitioner. Okay,
Lordship.
has prayed for adjournment of the matter.
That
Accordingly,
30.
list after 3 weeks.
4
Ah,
weeks, lordship. I
list
take
after
consent from
4
other side.
weeks, 4 weeks. Then in item number 32, it will be for the appellant. Okay, same,
Obliged.
yes.
May it please your lordship. Lordship, I would like to mention item number 29, lordship. In this matter, the respondents have filed their affidavit in opposition last week, lordship. We have received it. We need 3 week times to file our rejoinder, lordship.
Okay, Mr.
Hardeka, lordship.
R. Deka, learned counsel for the petitioner, has prayed for time to file their reply affidavits to the counter affidavit filed by the respondents. In view of the above, list after 3 weeks.
Much obliged.
Yes.
Well, we'll call for the case there, Your Lord.
Okay, bill application.
One
Have
in-
you approached the court below?
My lord, the fact is something very different in this case. What had happened earlier, this two applicants, my lord, their husband and the wife, 1 and 2, item 1 and 2, my lord, on the same case. So what had happened, a revision petition was filed against the discharge by the learned trial court, the same trial court, and then bail was moved and was rejected. Now
Okay, by the
they-
trial court, huh?
they were in the incarceration for long now. So then what had happened after that appeal against revision petition was filed against the discharge. Then in the meantime, the accused was murdered. So but
Was
murdered. Anyway, that typical in our tribal society is still that revenge system prevails. But then this husband and the wife, the item number 2 is the wife. Both of them, in fact, made a effort so that the person who has murdered should be taken to the police station for surrender. But that was not materialized. In between, they were booked under this. So therefore, we have case diary at this moment.
So, no, here you're saying that the matter now is pending before the trial court, isn't
Yes,
it?
yes, yes.
Sessions judge.
Session Judge Bomdila.
So have you applied for bail before
We
the
applied,
session?
we applied. and
It was rejected?
It was rejected.
Okay, yes. Because don't come directly to the High Court. I've seen some anticipatory bail applications also where they've come directly to the High Court.
No, my lord, that-
Yes, heard Mr. So-and-so, learned counsel for the applicant who has filed the instant application under section 439 of the Code of Criminal Procedure for the release of the alleged accused who was arrested on bail, who was arrested on 13/11/2023 in connection with SEPA PS case number 106/2023 dated 30/10/2023 under section 302/201/120B/34 IPC, which is pending before the sessions judge for the districts of West Kamen, East Kamen, and Tawang District, Bomdila. Full stop. Issue
And I have, for
notice.
convenience, I have given the list of the public prosecutors for your
Okay.
convenience, madam. I have
Yes.
submitted.
No, you're appearing, isn't it?
Yes, for
Ah.
this statement.
Issue notice to Mr. So-and-so, learned PP for the state respondent. Anyone else? Respondent number 2?
No, no.
No.
It's
Okay.
a statement.
Okay.
But in such case, the registry shall be requested to call for the trial court record. The
Yes.
scanned copy of the trial court record. It's always a registry.
Yes, yes, so-and-so, no need to issue any formal notice. And meanwhile, notice, list after,
My lord,
list in the next week,
my lord, may I request for
Ah.
7th?
list on 7/8/2024. In the meantime, scanned copy of the case records are to be called for. Yes.
Much obliged.
Item number 4.
Same order. Same order. Arising out of same.
Same order, same sections of law?
Yes, that's why.
Okay, fine. None appeared for the parties on call. What, you were sleeping?
No, Your Honor, I thought that item number 4. Lordship, this is an application under section 439 of CRPC, granting of bail to the alleged person in connection to Naharlagan PS case number 55/2024. So FIR is, Your Honor, brief is that on 25th of May 2024, Your Honor, officer in charge Naharlagan police station has lodged an FIR regarding that 4 person, namely Joram Taluk, Anuriba, Nani Kamdir, Golo Kuku, they were possessing some narcotic substance. So on the basis of that, Your Honor, the police has went to the spot and found that 17 plastic vials containing heroin, 25 grams, Your Honor.
Will you show
So what-
notice? Will you show notice first? Okay, you'd approach the special court.
Yes,
rejected
that
bail,
is
huh?
annexure number.
Yes,
Your-
yes, I've seen it.
Annexure number 5.
Mr.
Titopu.
State of Learned Counsel for the applicant/petitioner who has prayed for the release of the applicant on bail under section 439 of the Code of Civil Procedure. The Learned Counsel submits that the applicant was arrested on, when was he arrested?
Arrested on, Your Honor, 3rd of the June 2024.
0306/2024 in connection with what case?
Naharlagan PS 55/24. Your Honor.
See, the way of media application, I find it very difficult to find.
Find it in page number 2 also. Post title also.
Yes, it's only on the cost title, isn't it?
Yes.
In connection with Naharlagan PS case number 55/2024, under section 21 within brackets B/25/27/20 of the NDNPS Act. Issue notice to the respondents, Mr. So-and-so, Learned PP, accepts notice on behalf of the state respondent. Requisite copies of the bail application to be duly served to the Learned PP. List after,
On Monday, I picked up
a list on
Fifth
fifth,
of-
Fifth of August.
8/20/24. In the meantime, scanned copies of the, is it the
The case
LCR?
diary, case diary.
Case diary is to be called for. Yes.
That's all.
Lord, I am praying for interim protection. This civil dispute has been given to a criminal color. And then to attract section 420, read with
Sorry for interference, madam. This matter has been endorsed to one of the other additional PP. So this, if this matter can be taken up after some time.
Okay, time being matter.
Time.
no issue.
But actually, okay, time being.
Madam, this is joint application filed jointly by the petitioners. They are my lord informant, alleged inspection, and alleged victim, madam. My lord,
Okay, yes, will issue notice.
my lord, since this is quashing of an FIR, my lord, FIR, since the parties have already settled their matter, my lord.
Yes.
Yes, my lord. And they are also family
They are
relatives, my lord.
charged under what section?
My lord, 117(2) of the BNS, my lord.
Okay, what
Punish-
does it say?
Punishable up to my causing
What is
grievous,
the offense?
causing grievous hurt, my lord.
Okay, grievous
Yes.
hurt.
Punishable up to 7 years, my lord.
Okay,
And
medical evidence,
medical evidence,
medical report,
my lord, that is not annexed, my lord.
not annexed.
Not annexed, my lord. My
Has
lord,
it been charged yet? No.
no charges. My FIR was lodged only on, my lord, this one, 7/7, this month
Okay,
only, my lord.
yes.
7/7/24, my lord. And after the FIR, my lord, the parties had settled their
Come to us with
differences.
that,
Yes, that is on, my lord, 24/7/24, my lord. So within, after registration FIR, they have settled their differences, my lord. And moreover, their family relatives also, my lord. And offense is 117, that is punishable up to 7 years, and compoundable also, my lord. So, my lord,
What
till-
it is?
compoundable also, my lord.
Compoundable
Yes,
offense?
yes, my lord. Compoundable,
Okay, it's compoundable.
yes, my lord.
Then why don't you approach the court concerned for compounding the offense under the
Mal-
old section
mal-
is 320?
mal-
Previous offense, I don't think it's compoundable.
My lord, it is compoundable by the, my lord, victim, my lord. It can be compounded with a consent of the victim, my lord.
Okay, then I think they should
It's not
approach.
maintainable then in that case.
Uh,
They may appear before the consent trial court.
Then,
Compounding.
have you approached the concerned court?
No, my lord.
If it's a compoundable offense, approach a concerned
My
court.
lord, since this, since charge sheet has not yet been filed, my lord. Since this is,
So then it's CJM office?
Investigation is-
CJM court? Yes, CJM. Isn't it coming and running for compoundable offenses also? Then you'll be burdening this court with too much work, isn't it? So usually,
my lord.
okay, the old section, because I'm not, it will most probably be 5 to 8 now, okay, 5 to 8 of the, BNSS.
Yes, ma'am.
That will be, what? Okay, is made applicable when the offenses are non-compoundable, then the High Court is approached so that it can exercise its extraordinary powers to accept the compounding of non-compoundable offenses.
My lord.
Okay, so if this is a compoundable offense, then I think there should be a provision in the new act also that it can be compounded by the concerned court. And if it is still pending before the court of the CGM also has the power to accept the compounding of the offense. Isn't it? So go first. Unless you have already approached or made an attempt to approach, but for some reason it could not be done, then you can still come to this court, even for a compoundable offense, if you have made some attempt before the concerned lower court. I don't think you have done and made any attempt.
No, my lord. Since in that case, my lord,
Therefore, withdrawal
my lord, in that case,
and to approach the appropriate forum. Okay. What? Heard this- What?
My lord, in that case, because section, if it is really compoundable, I have to,
You have to see. whether
yes,
it-
my lord, so.
Heard Mr. So-and-so, learned counsel for the applicant slash petitioner who has prayed for time to verify whether the sections under which the incident petitioner have been charged are under compoundable offences or not. In view of the above, list in the next week.
My lord,
Okay, list on,
tomorrow, my lord,
okay,
tomorrow,
list tomorrow, okay, tomorrow's date. Finance?
Yes.
Yes.
Lordship, if I may. Lordship, this is a joint petition referred by three petitioners, Lordship. Basically, the petitioner
Yes,
number
we are more comfortable with the all old laws, isn't it? Yes. Yes.
my lord, the petitioner number one,
Hmm.
he was arraigned as a accused person in a supplementary charge sheet number 0522 of 22B in CBPS case number 7 of 2021.
Hmm.
Briefly stated, Lordship, the FIR is at page number 17. So, Lordship, the case started based on an FIR dated 25 June 2021, wherein the president of Arunachal Taekwondo Association, he made a complaint that some people are using fake certificates and documents for procuring government employees. Now, based on this complaint, an inquiry was made by the crime branch police station. The inquiry report is at page number 18. The
Page
type
number?
18. The type copy is 20. Now, basically, Lordship, after the inquiry, it was found that some people were indeed using some fake certificates, that they have not participated in those events, but they have procured some fake certificates, and then through the association, they have obtained certificates and they have obtained employment in government service. Thereafter, basing on this, Lordship, Annexure 2 is the first charge sheet. Charge sheet number 5 of 2022.
Okay, this is the Karate Association.
This is karate. I am a employee of Karate Association of Arunachal Pradesh. Now, in the first charge sheet, Your Honor, my lord, this around 19 accused persons were charged, my lord, but none of them were from karate. Only they were from taekwondo. Then, my lord, will see at page number 48. Now, this was a second charge sheet, a supplementary charge sheet. Now, in this supplementary charge sheet, my lord, 6 accused persons were charged. But even then, these were from this Tenikoit disciplines. These were not also from karate. Now, if my lord,
Discipline, which discipline?
I'm pardon, my lord, I'm having difficulty.
What is
Tenikoit.
Tenikoit? What sort of this thing, another form of martial art or what? Tenikoit is what?
Even I am not aware of this
Karate
discipline.
is Taekwondo and all are martial arts.
It's a form of
What is
sports.
this? Senior National Tenikoit Championship. What is Tenikoit?
Ring. Is a ring.
Okay.
That they-
Okay, you throw the ring
Yeah, throw the ring.
into some pole.
Yes.
Is it? Oh, okay.
Now, Lordship, the petitioner, now, the second supplementary charge sheet, which is annexed at page number 64. Now, herein, Lordship, the petitioner number 1, he was charged as forging some documents. Now, in this second supplementary charge sheet, 13 accused persons were charged. Out of that, 8 were candidates of karate. Now, if my lord will come to page number 82. If I may read, my lord, the portion below, Lordship, 10. Charges against accused Shankar Tamang. He is the petitioner number 1. As for the reports received from SFSL Bandardua, signature of so-and-so in form number 1, this person is petitioner number 2, Your Honor. Submitted by so-and-so, so-and-so, and so-and-so were scanned signature. Now, this is there, my lord. Further, as for the reply in response to notice under section 91 CRPC by Shri so and so, former General Secretary of Karate Association of India denied issuing any form number 1 certificate to the above mentioned candidates. However, the handwriting in form number 1 of so and so, the accused persons were found to be of accused Shankar Tamang, the petitioner number 1. As it is evident that all the forged form number 1 certificates were filled by accused Shankar Tamang under the above circumstances, prima facie under section 420, 468, 34 IPC is found well against accused Shankar Tamang. Now, Lordship, the basic allegation against me is that I have filled up some forms and a scan signature has been used for issuing form number 1. Now, basically, my lord, form number 1 is a verification that is given that this person has indeed participated in some events. That is there, my lord.
Anyway, so we'll issue notice first, isn't it? And then we'll hear whether it has to, should be. So you're saying that from the contents of the charge sheet,
Yes, Lordship.
the petitioner should be what?
He should not have been made an accused person.
Accused. Now, charge sheet has been submitted
Yes, Lordship.
at the time of consideration of charge, anything? That stage has
that
not
stage
been
is not reached.
See,
We are-
because this could be decided at time of consideration of charge also.
The issue here being the Lordship that we are also focusing on the merit also, Lordship, because we have been arraigned as an accused person without our involvement. Because, Lordship, if the charge sheet is perused, nothing is there. Because it is not a case that,
So what is the stage before the learned trial court? Before the learned trial court,
Lordship, the
there will be a
cognizance is not been
stage
taken.
when there will be for consideration of charge.
Yes, Lordship.
At the time of consideration of charge also,
Yes, Lordship.
he can be what, dismissed straight away?
Lordship,
No,
it can
no
be,
charge can be framed.
but
Then what?
Lordship, it can be done, but Lordship, why we have
Anyway,
approached-
we'll issue notice first and then let's see, isn't it?
Lordship,
Heard Mr. So-and-so, learned counsel for the petitioner who has filed the instant application / petition under section 482 of the Code of Criminal Procedure, 1973, for quashing the supplementary charge sheet number 05/2022 within brackets B, comma, under section 420/468/471/34 of the Indian Penal Code, submitted in the Crime Branch Police Station, case number 07/2021, wherein the petitioner has been arraigned along with the other co-accused persons. The learned counsel submits that on perusal of the contents of the supplementary charge sheet, there can be no case made out against the instant petitioner, and hence the instant application under section 482 CRPC for quashing the supplementary charge sheet. Issue notice to the state respondents, Mr. So-and-so, learned PP accepts notice on behalf of the respondents, requisite copy of the instant criminal petition to be duly served to the learned PP.
Yes, I'm SPP, madam.
PP,
SPP,
okay, special PP,
SIT.
okay, special PP,
SIT.
SIT. List,
Lordship, a small prayer, if it could be considered, a small prayer was there. A small prayer, Lordship, it could,
Oh.
if it could. Lordship, we have annexure 5 and 6. One is authorization and one is a agreement, settlement agreement between the parties,
Oh.
giving the clarification. Now, Lordship, these materials being not part of the charge sheet cannot be considered by the trial court. So at the stage of CC, Lordship, we won't be able to place these documents to prove our case, Lordship. So that is the reason that why we have approached the honorable court.
okay,
Lordship.
now, before saying issue notice, okay, the learned counsel further submits that
Lordship, that's why we have prayed for the
certain
interim order,
documents,
Lordship.
certain documents which were produced by the, by whom?
Petitioners,
By the petitioners, we also not made a part of the charge, supplementary charge sheet. Okay. Then in view of the work, so and so, continue. Okay. Yes.
Proceed.
Requisite copies to be furnished, list after. When will you be ready?
2 weeks.
2 weeks.
List after 2 weeks. In the meantime, scan copies required?
Yes, madam.
Scan copies of the charge sheet to be called for. Yes.
We also had a interim prayer, Lordship.
Good. Now, in the interim period,
Yes, Lordship.
if the charge is considered,
Yes,
CC, he could be discharged also.
Lordship, that's why we are saying that these documents, that we have annexed here, this cannot be considered by the trial court because these are not part of the prosecution's case, Lordship. So now the court will only be confined to what
Okay.
the prosecution.
Meanwhile, the proceedings before the, which court?
It will be for the learned JMFC, Lordship, UP.
Learned JMFC, which
UP.
district?
UP,
UP.
Papumpare district.
In, what is the case number?
CBPS case number 7 of 2021, Lordship.
Okay. So and so. 7 of
2021, Lordship.
2021
Yes, Lordship.
is to be stayed till the next date of listing. Yes.
Respect of supplementary charge sheet 5 of 2022B.
Okay, with respect of,
Supplementary
no,
charge
it will be against the petitioner only.
Yes.
Okay,
Yes, petition.
against the petitioner, not the others.
Okay.
Is to be stayed till the next date of listing. Yes.
Much obliged, Lordship.
Obliged.
Thank you, Lordship. My lord, here in the counter affidavit has been filed by the respondents. So I have to file a rejoinder, my lord. I may be allowed some time.
Okay,
This matter relates to tax, imposition of tax, where I have been exempted under section 1024.
okay. Heard, Mr.
SK Dewey.
SK Dewey, learned counsel for the petitioner, who submits that he may be given time to file his rejoinder affidavit to the affidavit, to the counter affidavit filed by the respondents.
Yes, ma'am.
Press
There's a
it out.
ultimatum.
List after
After 3 weeks.
3 weeks. In the meantime, interim order passed earlier shall continue till the next return of the date.
Obliged. May it please your lordship.
Yes.
Uh,
What is the IA about?
These are continuation petition, interlocutory application is a continuation petition for condoning the delay of 52 days in preferring the review petition, my lord.
Yes.
So I think the
Objection, written objection,
objection
no
has not
objection?
yet been filed yet.
Are you going to?
My
file
lord, we'll
objection?
file our objection, but due to this other parties concerning the same matter, there's uncertainty with the hearing date. So as if there could be a fix, that will come up with a objection with regard to the condemnation petition. As there are no specific reasons.
No, IA, this is IA
IA
93, isn't it?
Four
No, this-
IAs is there.
IA 93, I'm concerned with IA 93.
What about 96? What is this IA?
Similar matter, my lord. Condoning the delay of 52
Condonation of,
delay of 52 days in preferring review petition. my lord.
no,
till-
wait, we just get, now there's one IA 93, now, why are there so many IAs?
4 IAs, my lord. 4 IAs pertaining to 4 cases, my lord, review petitions. Since they are all similar matters, so this matter have been tagged.
Okay, then it has been wrongly reflected in the cost list because these IAs are in connection with some
Review petition.
review petitions which have not been mentioned. It's just the
Yes, which
IA.
have not been mentioned in the cause list. my lord.
Cause list.
Otherwise, the review petitions are also there along with the
So that's what, no, just simply IAs arising out of what? That's my question. So there are different review petitions.
yes, four
different
IAs for
review
4 review petition. The review petitions are review petition number 3, 4,
Yes.
5, and 6.
So in the cost list, no, it should be IA.
Along with the review
Yes,
petition.
in review petition, so
Yes,
and
ma'am.
so,
Yes.
then with IA in review petition,
Yes, ma'am.
different should be there, no? Otherwise, 4 different IAs for what? One single
Four,
case or
four,
what?
four
That
review
confusion
petition. My lord,
can
they-
cause,
basically
yes.
the transfer of the civil suit
Hmm.
from the different district of the Arunachal Pradesh to the UPA court.
anyways, so now what about the other IAs? You are for the first IA, 92?
No, I am for all the IAs.
No, no,
I am for item number, I number 93.
item number 9. What about the others? Is it the
Others,
still-
private respondents are not.
Okay, then. Now they have been clubbed together because it is arising out of the same judgment, it appears.
My lord.
Okay, heard Mr.
BK
BK Singh, learned counsel for the applicant. Along with Mr.
HK Jammu for
HK
private respondent in
Jammu.
item number 9.
Learned counsel for the private respondent in IA 93/2023.
My lord.
In the same IA
Yes, in
93.
all the IAs. In all the IAs.
Okay. None appeared for the private respondents in IA 94/2023, IA number 95/2023 and IA 96 in 2023. In view of the above, list these matters
On 5th of September, madam.
on 5th September
August. No,
2024. It is noted in the
For hearing.
in the
for hearing-
course list
for I-
that the
What about the other parts?
case
Any such-
out of which the instant IA has arisen is not mentioned. Registry to do the needful while in the next cause list with
Right.
regards to the instant cases.
Hello, an observation may kindly be made that on the next day, the effort will be made to dispose of the IA matter.
Oh,
Because
let them be present.
Their name has already.
Yes,
their
my lord,
name
the
are showing,
difficulty is there are other parties also. We are ready. However, the other parties, other
Ah.
private respondents, they are still not represented.
but their name has been shown in the.
But.
Whether the notice has been served,
Notice has been served. Notice has been served. We have taken dusty service and accordingly they have appeared and their name are shown in the cause list.
we,
my lord.
we are the only one who is appearing in this matter.
My
Since
lord,
this
kindly
IA has
the
been
last
filed.
order, they have taken some time for filing their objection.
So let's see in the next court date. Now, await for service report, await for service report.
Yes, ultimately we have taken
By
dusty service.
Dusty. Yes. We'll list the next date and see. Okay.
Obliged, man. So next date, 5/9.
5/9.
Obliged, man.
Obliged.
Lordship, in this case, we seek some more time, Lord. We are need,
For what? Counter?
Lordship.
Counter affidavit, yes.
We have not, we have
Mr.
yet to receive the
So-and-so.
instructions.
Learned, standing counsel, is it?
No, Lordship.
You are for? Learned counsel for?
Lordship, for
Government.
3.
Learned government advocate
Uh,
correspondent number 3 has prayed for further time to file the counter affidavit. In view of the above, list after
4
3
weeks.
Okay, after 4 weeks. Yes.
Yeah, the service of respondent number 8 or 9 has not been completed because his address is changed. So I may be allowed some time to
Okay.
take fresh
I
step.
heard Mr. So-and-so, learned counsel, S.K. Dori, learned counsel for the petitioner who has prayed for time to take fresh steps for issuance of notice upon respondent number
9.
9. Okay. In view of the above,
My lord, address may be corrected because
I will
in
correct
the
the cost
correct
type.
address, okay, in
he
the
has
correct
become the
address.
secretary land management also. He stays in civil secretariat.
I will
Earlier-
correct the correct
Yes,
cost
yes,
type.
yes, in the correct address. Accordingly, list after
After 3 weeks.
3 weeks.
Let him take dusty also.
Oh, it's up to, let him pray. He doesn't want to
Let's
take.
correct the
let's-
cost. My lord, there is an interim order, my lord. Interim.
Meanwhile, interim order
That's
passed
why-
earlier shall continue till the next returnable.
Well, this case, why I have made that prayer is for one reason, my lord. this involves with siphoning of the public fund. So therefore, any further continuance with this interim order will have a cascading effect. And this is very serious in nature, you know. You take
So
the
what is
money,
the correct
prepare
address for?
fictitious bill.
Let's see in the next.
Yes.
Is it? If you cannot issue notice properly, then you pray for this thing, that stay, isn't it? Hmm.
Item 4.
Yes. What is the stage?
Lordship,
Affidavit in opposition, not filed yet. Is it? Yes.
I am for the respondent number 6, my lord.
Mr. So-and-so, learned
behalf of-
counsel appears on behalf of respondent number 6.
Yes.
And prayed for further time for filing of the counter affidavit. In view of the above, list after 3 weeks.
My lord, extremely sorry for interference, my lord. In item number 9, my lord, my appearance may be reflected, my lord. Item number 9.
Item number 9, what?
9. In IA 90,
What? In
IA
item
90
number 9, what is your prayer?
item number 9, IA 95 and 96. I'm making my appearance on behalf of the respondent in this case, madam. Just my appearance may be reflected, madam.
Okay.
In IA 95 and 96.
Okay, the IA, those two IAs where no representation was made, is it?
Yes, madam.
Hmm. Okay, this is item number 9. Yes, so in item number, IA number 95 and 96
In both
You
the
can
cases, I'm
reflect his
representing
name.
respondent number
Okay.
1.
appears on, the private respondent?
Yes, madam.
Okay, private respondents, okay. Hmm.
Deeply obliged.
Lordship, in item number 15, Lordship, I was supposed to enter my appearance for the respondent number 1, 4, and 5.
What have we passed in 15? Item number 15. Oh, but what are you supposed to do? It's been listed after 2 weeks. For what? What were they supposed to do? Counter affidavit.
Counter affidavit, Lordship, we have filed, Lordship.
Okay, so fine. So it's no big deal. Respondent number 6 has prayed. So we have allowed. You want your name to be reflected?
Yeah, my name.
Okay, Miss so-and-so enters appearance on behalf of respondents number, you're the government advocate?
Yes, 1, 4, and 5.
Okay, government appears on behalf of the state respondents. Yes. Hmm.
My pleasure, Lordship.
Yes,
Item 20 to 23.
yes, 22, 23.
23. Lordship, on the last date, that is on 24th of, Lordship, on the last date, the respondent land management was directed to file affidavit on or before 26th of July. He has not filed, and the order was that if on the next date, that is fixed today, matter will be heard for disposal. Since he has not filed, matter may be heard.
Yes, my lord. In fact, the affidavit was ready that time also till today, my lord. But the officer who were authorized to swear the affidavit is left for training. So, my lord.
Affidavit is there, your file?
No, I have not filed, Lord.
Why?
Because the officer who was entrusted with swearing of the affidavit, my lord, is left for training, my lord. So therefore, my lord, since Deputy
It's
Commissioner
ready.
has already filed, my lord, matter can be heard, my lord. We will make our submission. Our submission. Since the Deputy Commissioner has already filed, my lord, that of course the affidavit filed by the department and the
Okay,
Deputy
so
Commissioner will
you,
send,
land
my lord.
management, it's not required.
Yes.
You'll not be filing.
Yes, my lord.
Okay, what is the matter about?
The matter is about land acquisition.
Hmm.
In brief,
Can we list it on Monday,
Lordship, Tuesday then.
on Tuesday?
Monday I'll
Okay.
be
Yes, yes.
no, sorry, Lordship. Let me see. Yes, on Tuesday, Monday I'm a bit.
It's going to sit for only 2 more days. Tomorrow and Friday it's not going to sit. Okay.
On Tuesday then, Lordship. Monday I'm a bit busy.
In the meantime, will you be able to file?
It may be reflected that the respondent land management will not file affidavit and the matter will be taken up for disposal.
Okay, yes,
Mm.
yes. Heard
No, just to be on the safe side.
Heard Ms. Duncan, learned counsel for the petitioners, along with Mr. So-and-so learned standing counsel for the land management department, respondents number 2 and 3, and
Respondent number 4.
Mr. So-and-so learned counsel for respondent number 4. And Miss So-and-so, learned government advocate for respondent number 1. It is seen that if the standing counsel for land management department is not, has not filed the affidavit,
Respondent number 2, Lordship.
okay, respondent number 2
Mm.
has not filed the affidavit, the matter is to be listed for hearing.
And that he said he'll rely on the affidavit filed by the
Mr.
respondent number 4.
So, non-standing counsel submits that they will not be filing the counter
My lord,
affidavit.
may just say that, my lord, in the meantime, if the officer comes back from the training, my lord, we'll file the affidavit, my lord, before this
It's
day, my lord.
it's been more than a year. They have not filed affidavit.
Next date, yes.
No, just now he said he'll not be filing affidavit.
But it's
Stick to
okay,
your,
let them
stick to
file.
what you
It's
say.
okay. But since we're not going to hear the matter today.
Yes.
We'll list it on, in view of the above. List the matter on what's Tuesday?
6th. 6th August.
6th August, so and so. Meanwhile, the learned standing counsel for land management department is given a final chance to file their counter affidavit, if any.
Yes.
And an endeavor will be made to dispose of the matter in the next date of.
Matter may be listed for admission. Today is listed for orders.
Okay. The registry to list the matter and the admission form. Yes.
And interim may be continued.
There's an interim?
Yes.
In the meantime, interim order passed earlier shall continue till the next returnable date.
Of
Yes.
late.
Okay, your lordship.
Yes. What is the
The
IA about?
application I for delay condemnation, your lordship. And
Yes.
a notice of
138 days. Who is for the respondent?
none of the respondent appear
Then
after a service of notice. And in the last occasion, your lordship,
You have filed an affidavit showing newspaper publication.
yes, yes, lordship.
What's the matter about?
It's a matter about
Appeal is for?
MSCD appeal
Appeal is for what? On what grounds?
for excess amount of award and
So who is respondent number 1 and 2, 1, 2 and 3?
1, 2 and 2 is a claimant and is
Who is appearing for the claimant?
none appeared. Yeah.
Then we'll have to give chance. Now here, it says that notice through newspaper publication is for respondents number
4 and
4 and 5,
Lordship.
isn't it?
Yes,
Now, what about the other respondents?
already served in a office note.
Wait,
1, 2 and 3 already served in 3/2/24.
they
And
received.
3rd of February, 1 and 2.
Wait for service report. You see, because The service report in respect of respondent number 3 has been received. The claimant is important. No one is representing?
No one
Respondent.
representing since
Okay, we can dispose of the condonation of delay then in the main appeal.
yes,
Maybe you issue fresh notice and then let's see, isn't it?
yes.
Then we'll have to hear the matter in their presence. What is the reason for delay?
Delay, Your Honor, there is in this case, the engaged advocate of the petitioner who appeared in the lower court, he have submitted the report and the judgment take some times, and the branch office required some instruction from the regional office. That's why they have sent the judgment and order and the report of the advocate.
This thing, we'll pass such an order that we'll list it in the next date. And if none appeared for the respondents, the matter will be heard in the absence of I think we should give one final chance. Heard Mr. So-and-so,
Speak one.
learned counsel for the applicant, who submits that notice has been served to respondents number 4 and 5 through newspaper publication, and affidavit to that effect is duly filed. On perusal of the affidavit, it is seen that newspaper publications dated, what is the date of that?
25,
Let's see.
Your Worship.
Wait. where's
25 7th of
newspaper?
this
This is
month.
the affidavit? Okay. Newspaper publications in Arunachal Front.
Times. And Arunachal Front.
Arunachal Front dated
Dated 25 7.
25 July 2024. Yes, very recent, no? 20 and
In the page number 3 of Arunachal Front.
Arunachal Times dated 25 July 2024. The newspaper were made, and the copies of the newspapers have also been enclosed in the affidavit. In view of the above, this court finds that notice upon respondents number 4 and 5 is deemed to be complete as per true newspaper publication. Okay, cancel as per. None appeared for respondents number 4 and 5. It is seen that respondents number 1 to 3 have also not been represented, though notice was deemed to be duly served to respondents number 1 to 3 as per the office note dated dated
Office note
wait, let me
part
just
of
see. I saw it.
February
Yes,
and
third, as per office note dated 03/02/2024 and
8.
08/02/2024. This court, however, find it fit to give another chance for the respondents to be duly represented. List on, give me a date,
19 August. Lordship.
19/8/2024. We'll just give them a chance. Okay, time being matter. Item number 4.
Well, this commercial dispute has been given a criminal color, and criminal law of motion has been set into by filing this FIR. My lord. From the content of the FIR, my lord, it is quite discernible that there was some agreement
Now,
between
before
them.
that, have you approached the sessions court?
My lord, It is not a
It
requirement.
is not necessary, but the usual procedure, which is also
No,
followed
No,
in
no,
the
but
other
earlier,
benches.
earlier, there was a judgment by this court only.
Huh.
But that was later on, it was decided that one can.
Where?
But I,
You know why I'm saying this?
Hmm.
Because if there's going to be an appeal, now you will have to approach directly to the apex court. Okay, so this step, approaching the sessions court and then the high court, if there has been given in the for the benefit of the applicant.
no, my lord,
And also this.
No,
So I think you should know, you approach this thing, unless you give me the
No,
judgment or the
no, but-
procedure, because that's what is followed in other benches also. Okay,
No, but-
yes,
uh,
yes.
this is anticipatory bail, my lord.
And for anticipatory bail
Anticipatory
matters,
The district and session judge
Huh.
and the high court exercise the parallel power.
yes.
So
but-
therefore, the statute provides
Huh.
that any litigant can approach any of the forum.
But-
Therefore, my lord, there is a
Yes,
doctrine of forum convenient.
Huh.
So, my lord, for sake of that litigant relegating to a district court may not be warranted at this stage. So therefore, my lord will exercise. And it is at the peril of the applicant missing one forum. So therefore, my lord, that doctrine of forum convenient is there. So once there is a
Where's
forum
he from?
convenient,
Where's from? You see, where's he from? That he cannot approach the sessions court.
it is not mandatory under law, my lord.
It is not mandatory, but the usual procedure which is followed.
My lord,
Okay.
my lord, kindly
And the
appreciate.
reason is that if the anticipatory bail is not granted by the High Court, your next step will be to approach the Supreme Court,
No problem.
isn't it?
The litigant.
So it is in the interest of the litigants that I don't have the judgment straight away with me, unfortunately.
I
Okay.
also have not.
Uh-huh. So it is in the interest of the litigants that the usual procedure would be for them, if there's a provision for, they can approach either of the courts, to first approach the sessions court, and thereafter, okay, it should go, in appeal, they can go to the High Court. That two-step tier has been made. Okay, so
My lord, with greatest respect, my lord,
Mhm.
with greatest respect, any rules or the procedures cannot override the objective of the institute.
but it is
What
in the
because that
interest,
celebrity judgment,
uh-huh. Yes, yes.
judgment,
Uh,
if the statute provides that a thing is to be done in a particular manner, you have to do in a particular manner. So therefore, my lord, the apex court also has made it clear. Now it is a question of forum convenient. The convenient is what? The litigant wants that I will miss the lower court, I'll come straight to the
So
high court and take a rest.
all applications, otherwise most of them, then they will come directly to the, so no, there is, I cannot cite it straight away, okay? But there is this, and the reasons that was given, okay, the reason that was given was it is since this thing, if the anticipatory bail is rejected by the High Court, the only remedy that he has is to approach the apex court. Okay.
No, there is a
So
concept of subsequent bail also.
this trial, this thing, okay, this tier, okay, should be followed as closely as possible or something like that. Okay. So we will adjourn the matter.
My lord, please, may
In
not
that case, my
adjourn.
lord, this matter can be fixed tomorrow, so that even I'll go through the citation and I'll just place it if required, my lord.
Okay.
In respect of the procedural part.
My lord, there is one clear thing.
No.
Earlier, I also remember there was one judgment by these, the
Okay,
principal bench,
bring that.
which says that you come to you approach the lower court first.
Yes, yes.
But that has later been done away, or for the
By,
reasons by our high court only.
Okay,
The
so
criminal
give
rules
those
were-
judgments. Okay, give me those judgments. Come prepared. We'll list it tomorrow.
My lord, whatever it is, my lord, for the moment, I
Uh-huh.
try to convince my lord, and I put
Yes.
one circumstances before my lord. Now,
Maybe I'm recollecting the judgments which you are mentioning, and I want to see how it has been done away with. Okay, because I'll tell you, in the
Now-
other
now-
outlying benches also, This is the procedure we follow and they do it. So I want to be very careful, okay? So we'll list the matter tomorrow. Give me, bring with those, this thing, where, show me where it has been done away with. Because, if it, maybe it was a division bench who had mentioned that it should be there. So if that has been done away with, let's see, so that it'll be for the interest of everyone, isn't it?
Well, just for a moment.
Uh-huh.
A contra-
That reasoning is there because.
a par contra view from my side. The par contra view is that, suppose if there is a rule that has been framed by the High Court, now any rule, suppose the service rule, it flows from Article 309, then under sub-delegation, the delegating officer frames the rule to make the law applicable. Now here, similarly, suppose the objective, it is an enactment by the central government.
Yes, it is,
once the enactment is done, can the rule or subsidiary rules can override this statute?
But if there are judgments.
And the answer is, my lord, respectfully not. Respectfully not, my lord. So therefore, any matter, my lord, whether it is a anticipatory bail or a regular bail, my lord. Suppose, my lord, 439, the jurisdiction is exercised by the session court also. And this court also. So therefore, it is a sine qua non for both the institutions. So you do not have the carte blanche right that you go this side and I go this side.
So bring the judgment which has done away with the judgment of the division bench.
I'm trying to assist my lord, because tomorrow in that event also, if there is a judgment also, but
the Supreme Court judgment makes certain judgments doing away with certain laws, then it is for the parliament to make the amendments. For the parliament to make the amendments.
On this jurisdiction.
Because uniformity should be followed in all the benches.
Principal bench Guwahati does not do so. Directly people are filing. That is the case. Recently I have done it. Anyway, my lord, I appears in principal bench also, here also.
So let's see what is going on.
Say for example, now what happens is, in bail jurisprudence, many courts, including our apex court, with courteous respect, so that I should not be drawn to a perjury or the contempt. The judiciary always gives a two view on the bail jurisprudence. The first view.
So you give your
because
reasons.
Of these, my lord, the
you
bail
give your
jurisprudence
reasons. You give your reasons.
Citizens are at large.
You give your reasons why you cannot approach the district and sessions court. The sessions court, what is your difficulty and why you have directly approached this court? Because the procedure is that you should actually follow. Yes.
Here is a situation, this case, why I am insisting for one purpose. I am from West Siang district. FIR has been lodged here. Where should I go? Now the section 177, the territorial jurisdiction will come. Now in that event, the complainant is from here. The complainant is from here. I am from West Siang. The immediately 177 comes in.
So where has the case been filed?
If a FIR is filed here, they can always approach the concerned session court.
Yes. So we'll look at you tomorrow. You come with your, be ready, okay, with your.
That's why sometimes if these kind of issues come up, just that statement I was making. It's a Jagjit Singh judgment. Now Jagjit Singh judgment has created a lot of problem in this country. Because although it has given the participatory right for the victim, but then the manner how it has to be conducted, the rule has not been framed.
Yes.
Similarly, my lord, in the bail jurisprudence, my lord, I'm speaking from my heart, my lord.
Yes.
On my concerns on the bail jurisprudence. Since I have gone deeper in this, very recently I came across this bail jurisprudence has been compounded by the judiciary itself. Because there are always two views. Sometimes, my lord, in the POSCO and the 376 case, the judgment says, Satyendra Kumar until judgment also says that whatever seriousness the offense may be, bail must be granted. But again, in the recent this thing, my lord, that Delhi liquor scheme judgment and ED cases, there it says no, bail should not be granted. Now this somehow, somewhere, my lord, this particular aspect has to be dealt with in order to maintain judicial discipline. Because there cannot be contradictory view on the bail jurisprudence. At the inside, my lord, we'll see the personal life and liberty. Bail jurisprudence is based on Article 21 of the Constitution. That's all. And then, even then, my lord, sometimes what happens? Now, for example, I give one example. There was a POSCO case. The learned special judge granted the bail, and the High Court taken a suo motu note and taunted the lower judiciary. Now, today, my lord, in Arunachal, my lord, not only Arunachal, because of that, all the outlining benches, wherever the honorable judges are exercising power under 439 on the POSCO thing, they are afraid, their hands are packed. Therefore, my lord, these are certain aspects. I'm speaking, as an
I
citizen, my lord.
understand. So we'll delve into this a little bit deeper.
This aspect, I'll come back.
Okay, come, we'll list it tomorrow.
Right.
Okay. Yes.
May I please, my lord? My lord, here I'm appearing on,
List. Yes.
my lord, I'm appearing on sole respondent
Ah.
the matter, so I have already filed my affidavit. Affidavit in oppositions.
Yes, so
Yes, Lordship. So we will receive the copy of the.
Maybe they will take time for,
you want to pray for adjournment?
Lordship, pardon, Lordship, we, if deemed necessary, we will file a reply, Lordship. We only
You
give it
want-
1 week time.
Okay, on the submissions made by the learned counsels for both the parties, list in the next week or after 1 week?
After 1 week.
After 1 week.
Lordship, there's
Yes.
interim order, it may be.
Meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
yes, my lord, this is a criminal petition for causing of FIR, my lord. Petitioner has jointly filed and the matter was mutually settled in the outside of the court.
Who is for,
Government.
okay, in the meeting, now here, this last court's date, it says that petitioner is permitted to file
Yes,
affidavit.
my lord. Last occasion, I was directed to file additional affidavit in regard to petition number 2 and 3.
Okay.
So my lord, I tried to file additional affidavit. One of the petitioner is residing in Assam.
Okay, so you need some more
yes,
time?
Yes, yes. So
Okay.
I need some more time.
Yes. Heard Mr. So-and-so, learned counsel for the petitioner, who is prayed for further time to file the additional affidavit. For petitioners number 2 and
2 and
3.
3, madam. 2
In
weeks,
view-
madam. Matter may be listed.
In view of the above, list after 2 weeks.
Much more.
Yes.
My lordship, Your lordship, in this case, you are the joint petitioner, both the petition number 1 and 2, were husband and wife. So, Your Honor,
So who filed the FIR?
file the petition number 1, the wife.
The
Yes,
wife
Your lordship.
filed the FIR.
Yes, Your lordship.
So he must, what did he do to the wife?
Your
caused
Your
her
Honor,
hurt?
the
Confined
petition
her?
number 2 has been booked under section 498A of the IPC and 506 323 of IPC. 498 talks about husband or relatives of husband of a woman subjecting her to cruelty.
Counsel for the appellant is present along with Mrs. So-and-so, learned additional PP. However, it is seen that none appeared for respondent number 2. Who's the counsel?
Tadu Bayor.
Adu Bayo.
T Bayor for the
And-
victim.
And because of him, case is delayed. Because he is the death peer. At that time, he is the advocate. We are not getting him all the time.
Otherwise, your lordship, the accused conviction has been suspended, your lordship.
Suspended. Okay,
Yes.
then, in view of the above, list, give me a date. In the next week?
Next.
After your
list
lordship,
matter.
after 2 weeks, your lordship. In the meantime, I will inform the other side.
Yes,
lordship.
Okay,
It will be better.
List
to inform.
in the list
Particular
after
day,
2 weeks. In
Yes.
the meantime, learned addition PP to take steps to inform the learned counsel for respondent number 2.
Obliged, deeply obliged.